Articles of Association of a limited liability company. Memorandum of Association, through its clauses domicile, objects, liability and capital, decides the external boundaries for the business operations of a company. It clarifies the area beyond which the company's actions cannot go. Memorandum answers the question who, what and where about the business of the company. Inside this area, shareholders decide on the regulations for business operations. Such regulations are collected and mentioned in the Articles of Association. Effectively, Articles of Association are a collection of the rules of the game which defines the way company and its business is carried on. The rules of the game are also known as bylaws or stipulations. They are very comprehensive in terms of binding the relationships. They bind the relationship between company and its members, and even within the community of members, it binds the relations between members inter se. Section 4 deals with both memorandum and articles. It highlights articles are to be printed mandatorily with the numbered paragraphs. The model forms of Articles of Association are contained in tables F to J of Schedule 1. Table F pertains to companies limited by shares. G and H are connected to companies limited by guarantee, and I and J are used by unlimited companies. Companies articles will be quite comprehensive, covering each and every aspect of the rule of the game, but to the extent there is a gap, model form of articles in table F is by default attracted in respect of a company limited by shares, and similarly from the respective models for companies limited by guarantee and an unlimited company. While the companies have the flexibility to draft their articles, they have to ensure that the articles are in compliance with the provisions of Companies Act and any other applicable law. The articles cannot limit or restrict what is provided in the Act, nor can they permit what is prohibited under the current law. Articles as rules of the game will be quite comprehensive. For example, in respect of share capital, they will cover every minute aspect pertaining to transfer, transmission, lien, forfeiture, convening and holding of a meeting, voting rights of members, variation of rights of shareholders, dividend policy, management of reserves, capitalization, buyback, and every possible transaction which is likely to come up in the course of business. Companies always go very comprehensive and minute while forming the rules of the game. They will cover on an overall basis topics like share capital, directors, their meetings and their powers, CEO, manager, secretary and CFO, their rights and obligations, common seal and procedures pertaining thereto, accounts and audit, and winding up. The idea is to cover every aspect of a transaction that is likely to come up in the course of business operations of a company. Every subscriber to the Memorandum of Association will be signing the Articles of Association. Each signature will be attested by a witness, and full details of every subscriber, including his association with any other companies as a director or promoter, will be forming a part of documentation in respect of the articles. Section 14 authorizes alteration of articles by special resolution. It will be as effective after the alteration as before. However, it can be only prospective in its impact. It cannot have a retrospective effect. An alteration has to fulfill two conditions. One, it has to comply with the provisions of law. Second, it cannot contravene contents of the Memorandum of Association. I am Vittal Prabhu, bringing you the weekly video on business law refresher. Hope you will find the video interesting and useful. The doctrine of constructive notice stems from the nature of memorandum and articles as public documents open to all, being documents filed with the ROC. The doctrine expects every person dealing with the company to have read and understood the documents according to their proper meaning. This doctrine protects the company against any claims from outsiders based on their ignorance on the contents of memorandum or articles or both. The doctrine of indoor management gives relief to an outsider for any internal lapses on the part of the company. It states a person contracting will not be prejudiced by any irregularities in the internal working of the company. The rule came into prominence with Royal British Bank versus Turkand 1856. The relationship between memorandum and articles is quite special. Articles are subordinate to the memorandum. If the two are inconsistent in terms of any provision, the articles must give way and memorandum prevails. So long as an activity is done within the boundaries specified by the Memorandum of Association, whatever done in contravention of articles is just irregular. It can always be confirmed by the shareholders. Any act beyond the spectrum of memorandum is not ratifiable. If something is done beyond the Memorandum of Association, it is absolutely void and it is altogether incapable of being ratified by shareholders.